6A, Financial Administration. Financial Administration. This is 6A1 by Adam Nugent Rosenberger. 6A1001, District Financial Records. The superintendent of the schools of each school district shall be responsible for keeping adequate records and accounts of all financial transactions in the manner prescribed by the Commissioner, and the publication of that titled Financial Program Cost Accounting Report for Florida Schools 2004, FloridaRules.org, Gateway Reference ASP number equal reference to 04652, which is hereby incorporated by the reference in this rule. Copies of the publication may be obtained by the Office of Funding Financial Reporting, Department of Education, 325 West Ganey Street, Tallahassee, Florida 32399, at the cost to be established by the Commissioner, but which shall not exceed actual costs. Rulemaking authority is 1010-01 for state law, implemented 1010-01 Florida State History, amended in September 17, 1970, promulgated in December 5th, 1974, amended in April 28, 1979, August 2nd, 1979, June 21st, 1980, October 7th, 1981, August 1983, September 27th, 1984, October 1st, 1985, formerly 6A101, amended in 11, November 8th, 1988, July 30th, 1990, October 6th, 1992, October 18th, 1994, January 26th, 1998, October 15th, 2001, and December 20th, 2011, as well as November 13th, 2012, November 3rd, 2013, and November 4th, 2014. The Data Collection Activities Instrument Reforms and Instruction Rulemaking Authority 12053-1B 229-053-1 for state law, implemented in 12053-1B 229-053-1 229 6 12 13 229 551 229 555 235 014 235 14 41 for History News, February 21st, 1977, amended in April 28, 1977, and August 8, 1977. March 1st, 1978, September 6th, 1978, October 30th, 1978, April 20th, 1979, December 11th, 1979, March 16th, 1980, May 29th, 1980, August 16th, 1982, formerly 681-011, amended on 10/18/94, repealed in May 19th, 2008. Minimum security measures for direct deposit of electronic transfers of funds or other medium. A district school board may establish policies to authorize an electronic or other medium the recipient disbursement transfer public funds and warrant to and from within the official accounts of the financial institution, provided with adequate internal control measures are established by the maintained. Minimum security measures shall include but are not limited to the following. Each financial institution shall be specialized, authorized by a school board or such financial institution, such as specifically agree in writing to accept monetary transactions through the electronic or other medium. To be authorizing agreement shall contain with the official title of the bank account, subject to the agreement, each type of the transaction and proof, such as deposit, disbursement, transfer, and each person authorized to initiate the transaction, manual signature of each of the authorized person, the manual signature of the school board chairman, minimal manual signature of the school superintendent. When funds are properly delivered to a receiving institution, the institution shall agree to become the responsible for the prompt, diligent processing of the funds. The written confirmation of all transaction forwarded to the financial institution shall be signed by both the authorized person making transaction shall be included, retained in the official files of the school district. Written and printed documentation of each of the financial institution acknowledge such as transactions, including but not limited to deposit slips, debit, credit memos, trust receipts, transfer acknowledgments, canceled warrants, shall be kept in the official files of the school district. These files must be maintained at a minor facility, easy of the review of the validation of the transaction. 2. The district school board, by agreement of the individual's financial institution, may authorize direct deposit of the funds to pay account and authorize cancellation from each of such payee should be written in the filing district office, and each authorization shall include but not limited to the following information: name of the individual shown on the official records of the school board, social security number, name, manual signature of the payee as shown in his or her bank account. The date of authorization cancellation is to be effective within the schedule provided by the school board. Name, address, Federal Reserve Bank number of the institution designated for the payee to the receive deposits. Written assurance of the designated financial institution is prepared and will accept responsibility for the funds in the form of the presented on the dates of authorized. The documentation of each of the transaction shall be maintained in the official files of the districts in sufficient manner to assure the internal control over the transaction. The rulemaking 101021 and 1011-18 of the law implemented 13606, 215-85, and 1011-18, Florida State History News, December 4th, 1979, formerly 6A102. Audits and direct support audits and direct support organization. The official year of the Department of Direct Support Organization shall begin with July 1st and June 30th. The following of each of the official year of the Florida Education shall provide the audited Department Direction Support Organization to be conducted by the independent certified public accountant in accordance with the American Institute Certified Public Accountant auditing standards. The audit report shall include notations of any failure to comply with the requirements of Florida State Statute, State Board of the Rules, Direct Support Organization, corporate charters or bylaws, commentary as financial management irregularities. The auditor shall be submit a signed written report of the director, each member of the Florida Education Council, of the Auditor General and State Board. Audits and Direct Support Organization. The Department Direct Support Organization, authorized by the Department of Property, Facilities, Personal Services, are determined annually by the Commissioner to operate the Direct Support Organization. For the official year of the Direct School Board Direct Support Organization shall begin with July 1st and it shall end on June 30th. By the following close of each fiscal year, the board directors of each school board direct support organization shall provide with an audit of the school board direct support organization to be conducted in accordance with the American Institution of Certified Public Accountants auditing standards, independent certified public accountant by qualified internal auditing staff employed by the school board. The audited report shall include notations of any failure to comply with the requirements of Florida State Statute, State Board rules of the direct support organization, corporate charters, bylaws, commentaries of the financial management irregularities. The auditor shall submit a written report to each of the members of the board directors of the direct support organization, to each member of the school board, and to the superintendent. The audits in the direct support organization rulemaking authority is 100101, 100124, 1001-453. Florida State laws 100124, 1001-453. Florida State history is in June 6, 1985, formerly 6A1013. Comprehensive Management Information System. Each school district and department shall develop and implement an automated information system component which shall be part of the compatible with the statewide Comprehensive Management Information System. Each information system component shall contain automated staff and financial information systems such include procedures of the security, privacy, retention, automated records procedures, security, privacy, retention, automated student records shall be in accordance with the requirements of Title 20 U.S. Standard Code 1232 GB3 34 Code Federal Regulations, Part 99, and Section 1002-222 for state statutes. The data element and procedures of the timeline for reporting local recording, comprehensive management information, the data elements, procedure timelines for state reporting local record, keeping state records with the transfer implemented at each school district department within an automated information component is prescribed in the publications entitled the Department of the Department of Education Information Database Requirements of the Volume 1 Automated Student Information System 2012 Florida Rules Gateway / reference ASP question mark number that equal the reference 23480 23448 Department of Education Database Requirements Volume 2 Automated Staff Information System 2012 Florida State Rules Gateway reference ASAP equal question mark number the reference is 2349. And the Department of Education Information Database Requirements of the Volume 3 Automated Financing Information System in 1995. The publications include department procedures of security, privacy, retention, and the school district student and staff records collected, maintained at the state level, and hereby incorporated by the reference made by the part of this rule. Copies of the publication may be obtained by Education Information Accountability Services, Department of Education, 325 West Gainey Street, Tallahassee, Florida 32399. Comprehensive Management Information System. If any portion of the rule reference material is adversely affected by the courts, the affected portion shall be considered repealed or the rule shall be re-promulgated. The rulemaking authority through a comprehensive management information system starts with 1001-021, 1002-22, 1008-385, 1008-40-12, and the Florida State Law implemented 1001-23, 1002-22, 1008-385, 2, 1008, 441. 2, the history news of February 29th, 1987, and amended in December 21st, 1987 to December 13th, 1988. March 25th, 1990. March 24th, 1991. March 17th, 1992. December 23rd, 1992. February 16th, 1994. March 21st, 1995. July 3rd, 1996. May 20th, 1997, October 13th, 1998, October 18th, 1999, October 17th, 2000, May 19th, 2003, and July 20th, 2004, April 21st of 2005, March 1st of 2007, March 24th of 2008, and November 27th, 2008, December 15th, 2009, February 1st, 2011, January 16th, 2012, and March 26th, 2013. The application for insurance and the revocation of master school identification numbers. The master school identification number is a unique number assigned for the Department of Education to a public school as part of the statewide comprehensive management information system for the maintaining and reporting education records, referencing and supporting education accountability, supporting the distribution of the funds, districts, and school district financial report, assisting Commissioner of the Education in carrying out the duties specified in Section 1001, 10, 1001, 11, and 1008, 31 Florida State History, Florida State Statutes. The application of the Master School Identification Numbers. The application shall be made by the entitled Florida Department of Education Master School Identification Application Form for the MSID 01. This is Florida Rules Gateway Reference ASAP number. The reference 03694 for F. The form is effective in March 2014. As incorporated, the reference is available online at the Department of Education web /PRD Department of Education State Florida US EDS Master School ID /index CFM. A hard copy may be obtained by contacting the Division of Accountability Research Measurement, Turlington Building, as Suite 844 of 325 West Gainey Street, Tallahassee, Florida 32399. The master application insurance revocation and revocation of the master school identification numbers. The time frames of the submission of the master school identification number application are as follows. The charter school, the master school identification numbers of applications must be submitted by the department by the district with 30 calendar days of the approval of the charter school. The application by the district, the Department of Juvenile Justice, Adult Health, Hospital, Homebound, and virtual schools may submit the master school identification numbers applications to the department throughout the calendar year. All other applications shall be submitted by the department no later than June 1st, or no either than 3 calendar years being prior to the school year that is school is to open. The master school identification number. As a master school identification number submitted to the department 1 to 3 calendar years in advance of the school opening, remaining in activity until the district requests activation or requests of the activation shall consist of the submission updated of the master school identification numbers application form from the MSID 01 no later than June 1st of the prior to the beginning of the school year the school is to open. The master school identification number is used. The school prior to the school opening shall remain inactive until the school opens. Inactive MSID numbers shall be considered voided if the school does not open within 3 calendar years of the issuance of the MSID number. The Department of the Review of the Master School Identification Number application. The department shall notify the district of the missing information permit to the district 15 calendar days to supplement an application of the department and authorize the request of clarifying information anytime from the district. B. The department shall notify the district superintendent of the written of the approval or denial of any application. The department standard assignment of the MSID number. The department should assign for the department's standard assignment of the Master School Identification number. The department shall assign a Master School Identification number when the district demonstrates that the proposed school is functionally operating the district entity. The assignment of the Master School Identification number will not undermine the accountability of the following criteria. The review of the department to determine whether the standard assignment of the Master School Identification number has been met. A school has a principal that is not shared with another school. At least 50% of the school administrative teaching staff are not shared with another public school. School administrative staff means principals, assistant principals, and curriculum coordinators and deans. The school has separate populations of students enrolled in the school. A school is a separate location facility not shared with another public school. A school is not a school within a school as defined in Section 1003-024 Florida State statutes. F. A new existing school facility is populated in a new form student body is created by more than 50% of one or more of the previous school population. The student body has not relocated one of the school facility and another school is not a program with the school such as advanced placements, internal baccalaureate, international baccalaureate, exceptional student education (ESE), career academic is defined in Section 1003-024 Florida State statutes. The charter is approved and has been executed. Contract with the district. Any other factors regarding the school student population, administrative facilities. Administrative faculty and facilities of education program relative to the standard for the award of the master school identification numbers as set forth above. The department reviewing existing master school identification number, the department shall review the existing master school identification number, and when a school no longer meets the criteria set forth in subsection 4 of this rule, the department shall notify the district superintendent in writing prior to revocation of the number. The district shall afford the minimum of 30 calendar days to provide information to the department to support the maintaining master school identification numbers assigned to the school. The information includes the completed Florida Department of Education Master School Identification application form for the number of the MSI D01. The department is authorized and requested information school district in order to conduct the review of the master school identification number. District shall comply with the written request of the department information within 30 calendar days. District superintendent may submit a request to the department extension times. The department shall grant a request for the extension not exceeded for 85 days. If the request is submitted with the written and received in 30 days of the department original request of the information, the department shall notify the district superintendent in writing of the approval of the denial of the extension. The department shall review information provided by determining whether the school meets the standard set forth in the subsection 4, where the district has not provided the documentation demonstrating the school meets the criteria set forth in the subsection of this rule. The department shall revoke the school's master school identification numbers, notifying the district superintendent in writing. 6. The district responsibility. Any changes in information required in Section A5 of the sections A through F of the Master School Identification Number form, the MSID 01 requires the district school board MSID form that was updated information within 30 calendar days. A district shall submit all correspondence to the department regarding the Master School Identification Number to the Florida Department of Education Deputy Commissioner Division Accountability Research Measurement, Turlington Building, Suite 844, the 325 West Gainey Street, Tallahassee, Florida 32399, or as Ask EIA Act Easy Act Ask EI AS Florida at Florida Department of Education.org. The application for the issuance of revocation of master school identification numbers of the Rulemaking Authority 1001-02-29, 1008-385-3, the Florida State Implemented 1008-385-2A, Florida State History News of the March 25th, 2014. The 6A1002 District School Budgets. Annual budget for the District School Board shall be prepared for the form distributed by the Commissioner adverse presented to the public hearing pursuant to the advertisement adopted by the Board and submitted to the Commissioner in accordance with the schedule set forth in 6A10071 Florida Administrative Codes. When submitted by the Commissioner, budget documentation shall certified as official and correct of the original signature of the Superintendent of the Schools. 3. The forms ESE 139, District School Budgets checklist of the ESE 524 resolution determination revenues mileage levied are hereby incorporated by the reference made with the part of this rule, but effective with the effective date of this rule. These forms may be obtained by the Administrator of the Office of Funding and Financial Reporting, Department of Education, 325 West Gainey Street, Tallahassee, Florida 32399. Rulemaking authority for the district school budgets are 1001, 1010. 1010-01, Florida State Law Implemented 120-55-55 1A, 1011-01, 1011-02, 1011-03, Florida State History amended in September 17th, 1972, February 18th, 1974, repromulgated in December 5th, 1974, and amended in July 10th, 1985, formerly 6A102, amended in March 12th, 1986, October 13th, 1988, and September 22nd, 2008. The school district budget requirements. The district school budget shall submit to the Department of Education as a manner prescribed in 6A10071 Florida Administrative Code. The following items include the district summary of the budget, estimated revenue, federal, state, and local, estimated non-revenue loans, bonds, and etc., operating appropriations, transfer, debit services, capital projects, appropriations, and balancing and reserves. All budgets shall not be considered officially received until all required of the schedule and analysis certifications have been received, including the Form ESE 139 District Summary Budget. If Florida Rules Gateway reference ASAP equal question number the reference of 04653 ESE 524 resolution determination of the revenue mileage levied Florida Rules.org gateway reference ASAP a question mark number the equal the reference of 0465 04654. The ESE 139 and ESE 524 as hereby incorporated. The reference to become an effective number. The 2004 may be obtained by the administrator of the office funding of the Financial Reporting Department, Education, 325 West Ganey Street, Tallahassee, Florida 32399. Rulemaking Authority 1001-0221, 29, 1011-01, 2A, 3A, and 1011-61, Florida State 5, Florida State Law implemented 2000-065, 1011-01, 2A, 3A, 1011-61, 5, the Florida State History and Muse of March 26, 1966, and September 17, 1972, February 18, 1974, repromulgated in December 5, 1974, amended in November 29, 1978, and July 10, 1985, 6A104, amended in October 4th, 1988, September 22nd, 2008, March 13th, 2012, November 13th, 2012, November 19th, 2013, November 4th, 2014. 6A1004, budget amendments. No expenditure shall be authorized obligation incurred with the excesses of the budgetary appropriations. School board shall adopt the procedure when adjustment for the original budget are made as defined in order to comply with the rules. The school board shall approve the amendments to the district school budget whenever the function amount, object amounts to the accounts of the prescribed state board of the budget form that changed in the original budget approved by the school board. The school board budget amendments. The school board may adopt the procedure whereby amendments to the special revenue other funds are considered approved by the school board at the time the board approves an entitlement grant, and such grant application includes the budget summary, and the effect of such of the grant shall be reflected in the next monthly district financial report of the school board. No budget amendments shall be approved for the district school board after the due date of the annual financial report for the year. The Rulemaking Authority 1001-021, 1011-06, the Florida State Law implemented in 1010-01, 1011-06, 1011-06C5, 60 and 5, Florida State History as in September 17, 1972, and in February 13, 1974, repromulgated in December 5, 1974, and February 21, 1977, and January 7, 1981, and May 24, 1984, formally 6A106 as budget amendments. It shall be the duty of the execution of the budget. It shall be the duty of the superintendent of the school district school board to take whatever actions necessary during the fiscal year to keep the expenditures obligations within the budget income, provided that any amount of the appropriated the payment indebtedness during the first year shall be paid as the budget may have been officially amended. The failure to make such of the payment shall be deemed the violation of the school budget law. Any account execution of the budget. Any accounts carried over the previous year according to the previously principles of the accounting which are charged to the previous year business shall be paid with the first funds available to be made use of the purpose of the school board at no time including the close of the fiscal year shall be an overdraft the created shown against the funding of the depository account. The checking cash balances remaining in the district interest sinking fund or from proceeds of any bond issues no otherwise restricted after the obligations has been satisfied shall be transferred in other funds of the funds authorized by resolution of the school board. The execution of the budget rulemaking authority was 1001-02, 1010-01, Florida State Law implemented 1010-01, 1011-05, 1011-10, 2, Florida State History News of April 11, 1970, and September 17, 1972, repromulgated December 5, 1974, as in 6107 and amended in August 30th, 1988 is the execution of the budget. The following official reporting dates. The following dates shall be applied with official reporting of the budget processing each year. The school district final budget prepared under the procedural steps at the time intervals specified in Section 200-065 Florida State laws shall will be submitted to the Commissioner no later than the third business day following the day of the adoption of the school board. The annual official reporting dates. The annual official financial report of the official parts of therefore of the must be submitted by the Commissioner no later than September 11th of each year. The annual official year the composed of the following form of the ES 348, the report of the financial data, the Commissioner of Education, Florida Rules Gateway reference ASAP number, the reference 4657, and ESE 145, Superintendent's Annual Official Financial Report, Florida Rules Gateway references number equal to reference 04658. School reference maturity indebtedness and Florida Rules Gateway reference ASAP number, the reference 04659. ESE 523, information concerning authorized obligations under the section 1011-14 is in www.floridarules-gateway reference ASAP number, the reference of 4660. We are incorporated by the referencing rules of the becoming the effective November 2014. Therefore, these forms may be obtained by the administrator of the office funding of the financial report, Department of Education, 325 West Ganey Street, Tallahassee, Florida 32399. Official report dates. In the event of emergency, unusual circumstances, unwritten request of the superintendent of schools of the commissioner shall have the authority to grant an extension of the reporting dates not specified by the statute. The rulemaking authority was 1002-129, 1011-013A, 1011-61-5, Florida State Law implemented 1011-1, 3A, 1011-61-5, and Florida State History News as in September 12, 1972, and February 13, 1974, December 5, 1974, May 5, 1975, October 7, 1975, July 22nd, 1977, June 7th, 1977, and January 7th, 1981, July 10th, 1984, formerly 6A1071 amended in March 12th, 1986, October 4th, 1984, December 22nd, 2008, February 1st, 2012, November 13th, 2012, November 19th, 2013, November 4th, 2014. Financial statement. At least a month of the monthly, the superintendent of the school shall submit the use of consideration of school board financial statement in the form that prescribed by the school board. Financial statements for rulemaking authority 1001-021 of the Florida State Law implemented 1001-42, 1010-02, 1011-06 Florida State Law, Florida State History News as in September 17, 1972, amended in December 5th, 1974, formerly 6A108. 161008 Charter School Technical Career Center financial statements and financial conditions. The following provisions have been established to prescribe the performance of the Charter School or the Charter Technical Career Center's monthly quarterly financial statement required in the sections 1002-383, 9G, 1002-3411F, and the Florida State laws respectively to the administrator of the requirements of the section 1002-345, 4 and Florida State statutes monthly and quarterly financial statements. The Charter School and Charter Technical Career Center and financial statements of the financial condition of 6A10081. The Charter School Technical Career Center shall provide the financial statement to the school center of the sponsor in accordance with the section 1002-33 9G and into 1002-3411F of the Florida State statutes respectively on the form of IEPC /F1 Governmental Accounting Standards of the GSAP monthly financial form, and at Florida Rules.gateway reference of the number of the reference is 3235, the IEPC F2 nonprofit monthly financial form, Florida Rules Gateway reference ASAP number of the reference is equal to 03236. Hereby incorporated in the reference becoming an effective number 2014 from the EIPC F1 and EIPC F2 may be obtained by the contracting offices and independent education parental choice at 325 West Ganey Street, Tallahassee, Florida 32399-0400. The school shall provide in the notes of the financial statement, if applicable, including the information material of the financial system. The material is defined in magnitude of the omission of the misstatement of the accounting information that is in the light of the surrounding circumstances make probable that the judgment responsible person not relying on the information would have been charged and influenced by omission of the or misstatement. Charter and Charter Technical Career Center financial statements, financial conditions. The sponsor shall determine whether the financial statement must be prepared on a cash accrual basis or selected by the format shall apply to the schools or center in the district. C. The financial statement shall be formatted in accordance with the accountant's codes and prescribed in the publication titled The Financial Program and Costs of the Reporting for the Florida Schools, which is adopted by 6A1001 Florida Administrative Code. Charter school center and the sponsor shall agree in the written to the date of the financial students are to be submitted with the due date being no more than 30 days after the last day of the reporting period. Sponsors shall not require the monthly, quarterly financial statements are prepared by the independent certified publication unless otherwise agreed into in the charter or financial recovery plan. Furthermore, on charter schools and charter technical career center financial statements and financial conditions. The F, the reporting requirements of the subsection submental to any of the financial reporting requirements that are already established in the school or center charter. The deteriorating financial condition is defined as circumstances significantly impairs the ability of the charter school, charter technical career center to generate enough of the revenue to meet the expenditures without causing the occurrence of the condition described in section 218. 5.5031 Florida State law in current circumstances resulted with the result of the occurrence of the condition in the section 218.5031 Florida State statutes. If action is not taken to assist the school or the center, the deterioration of financial condition may be identified by one of the following ways. 1. The sponsor may determine the deterioration of financial condition existing with a review of the charter school, the charter technical career monthly quarter financial statement. Deteriorating financial condition may include, but not limited to, the existence of one or more of the following circumstances. School center and actual enrollment is in 70% of the less than projected enrollment for the budget is based on the enrollment and significant generated enough revenue to meet the expenditures. The school center actually expenses exceed budget expenses for the period of the last 3 consecutive months of the amount of the school does not have sufficient reserves to compensate. The school center experiences an on-budget financial event which in the charter school is insufficient reserves to compensate. 2. An auditor may determine the deteriorating financial conditions as defined in Section 1002-345-1A3 of the Florida State Statutes exist based on the annual audit performed pursuant by the Section 21839 Florida State Statutes. If condition is identified by the auditor, shall notify each of the members of the charter school, charter technical career center, the governing board, according to Section 21839F of the Florida State Statutes. Upon receipt of the notification, governing board shall notify the sponsor deterioration financial condition and write it in with the 7 business days. B. Upon determination under the subparagraph 2A1 of this rule of the receipt notification of the subparagraph 2A2 of this rule, deteriorating financial conditions exist, but the sponsor shall initiate expedited revenue notifying the governing board of the charter school, the Department of Education for 7 business days. The charter school sponsor shall develop a corrective action plan pursuant to the Section 1002-345-1C Florida State Statutes. 3. Developing corrective action plans. If the corrective action plan is required to do the charter school, the charter technical center failure to provide an audit failure or failure to comply with the statutory reporting requirements of the Commissioner shall maintain a record of the corrective action plan of the annual report required for the Section 1002-345-3 of the Florida State Statutes. If the corrective action is required but due to the identification, deterioration, financial condition specified in Section 218.503 Florida State Statutes, the Commissioner shall review the corrective action plan within written 30 days of the receipt to determine whether the strategies identified by the plan adequately address the financial challenges facing the charter school, the career charter technical center. The Commissioner determines if the corrective action plan is sufficient. The Commissioner shall maintain a record of the corrective action plan of the annual report required in Section 1002-345 of the 3 Florida State Statutes. Charter school, charter technical career center, the governing board shall implement monitoring the corrective action in accordance with Section 1002-33-9. J3 and 1002-34-13 Florida State Statutes, respectively. If the Commissioner determines the corrective action plan is sufficient financial recovery is needed to resolve the condition in charter school, the charter technical career center, it shall be considered in a state of the financial emergency pursuant to Section 218.5034C Florida State Statutes. The corrective action plan shall include the following components: a statement of the condition in Section 1002-3451 Florida State Statutes initiated developing of a correction action plan. A corrective action plan is required to do the deteriorating financial condition. The plan must include the 3 most recent financial statements submitted to the sponsor pursuant to Section 1 of this rule, the most recent annual financial audit, the description of the actions that will be taken, the result of the condition, including a timeline, a summary of the governing board's procedure to the monitoring implementation of the plan, a schedule of the governing boards to provide a progress report to the sponsors, any additional components deemed necessary to agreed upon the charter school governing board and the sponsor. And if the governing board of the sponsor are unable to agree with the the corrective action plan. A letter signed by both of the parties shall be sent to the Office of Independent Education Parental Choice, requesting involvement of the Commissioner pursuant to Section 1002-345 of 1C Florida State Statutes. The letter shall include the statement of the condition 1002-345's 1 Florida State Statutes that initiated the development of the corrective action plan, a summary of the proposed corrective action for each of the party, written within 30 days of the receipt of the request. The Commissioner shall determine the components of the corrective action plan, including the reporting requirements for the governing board and monitoring requirements for the sponsor. Department of the State Financial Emergency, if the Commissioner is notified by the pursuant of the Section 1002-3452 and the A, one of the Charter School and Charter Technical Career Center, the financial auditor reveals one or more of the conditions specified in 218-503, the governing board and sponsor developing corrective action plan for submission of the review of the pursuant into subparagraph 3B of this rule. If the Commissioner is notified by the pursuant to the Section 218-5032, the state statutes and one or more of the conditions specified in Section 218-5031 Florida State statutes as occurred by the occur, and if the action is not to take who assist the governing board of the sponsor shall develop a corrective action plan for the submission and review of the pursuant to paragraph 3B of this rule. More on the Charter School and Charter Technical Career Center financial statements, financial conditions. 5. Developing financial recovery plans. If the Commissioner determines the charter of the school, the Charter Technical Career Center is in a state of financial emergency, the financial recovery plan filed in accordance with Section 1002-3452A2 Florida State Statute School with the Center Governing Board shall replace the existing corrective action plan created by the pursuant paragraph 3B of this rule. The financial recovery plan shall include the following components. 1. A statement of the condition identified by the Section 218-503 of the one of the Florida State laws resulted in the determination of the statement of the financial emergency, a description of the action that was resolved and prevent the condition of including a timeline, a summary of the governing boards or procedures for the monitoring of the implementation of the plan, a schedule for the governing board to provide progress reports for the Commissioner and the sponsor, the additional components deemed necessary by the school center and the governing board. The Commissioner shall review the approve the reject financial recovery plans pursuant to Section 218-5034 of the Florida State Statutes within 30 days of the receipt. Correspondence of all correspondence with the Commissioner of Education related to the financial condition of the charter schools of the Charter Technical Career Center shall be addressed to the Office of the Independent Educational Parental Choice at 325 West Ganey Street, Suite 1044, Tallahassee, Florida 32399-0400. In addition, with the electronic correspondence related to the school center and the financial condition shall be sent to the charter schools of Florida.org. That includes the notification of financial condition and identifying the Section 218 of 503 that has occurred with the request for the involvement of the Commissioner in creating a corrective action plan completed by the corrective action plans and completed with the financial recovery plans. The rulemaking authority is 1002-3327, 1002-345 of the Florida State Statutes Law implemented in 218-39, 1002-33-9G, 1002-34-11F, 1002-345. Florida history as in May 3rd, 2010, and amended in November 19, 2013. The project or construction accounts for capital outlay projects. A separate project accounts for the construction account shall be kept for all capital outlay projects which are subject to the provision of Section 1013-371-3 Florida State Statutes. The rulemaking authority is 1002, 1010-01, 1011-01-3 Florida State Law implemented 1013-371-3, 1010-01, 1011-01-3 Florida State Law, Florida State History amended in September 17, 1972, republicated in December 5, 1974, formerly 6A111, amended in December 4th, 1989. The 6A10112 purchasing policy. Each district school board establishes purchasing rules which shall include not but limited to by the following definitions. The term competitive solicitation shall be defined for the purpose of the rule included purchasing made through the issuance of an innovation and to bid. Requests of proposal innovation to negotiate competitive solicitation are not required for purchases made through the pool purchase provisions in Section 1006-27 Florida State Statutes. The invitation to bid shall be defined for the purpose of the rule written in the solicitation of competitive sealed bids. The invitation to bid is when the district school board is capable of specifically defining the scope of work for the contractual service and required for the district school board is capable of establishing precise specifications defined of the actual commodity or the group of the commodities required. A written solicitation includes a solicitation that is publicly posted. Invitation to negotiate shall be defined for the purpose of this rule as written in solicitation for the competitive sealed repeal replies to select one or more of the vendors which in the comments commence the negotiation for the procurement of the commodities of the contractual service. The invitation to negotiate is used if the district school board determines the negotiation may be necessary if it too receives the best value. A written solicitation includes a solicitation that is publicly posted. The term proposer shall be defined from the purposes of the rules, including the vendors submitting bids or responses to a competitive solicitation. Request for proposal should be defined for the purposes of the rule. Written solicitation competitive sealed proposal for the request of the proposal is used within its practicable for the district school board to specify and define the scopes of work for which the commodity group of the commodities contractual services is required when the district school board is requesting for the response vendor purposes of the commodity group of the commodities contractual services to meet the specification. Solicitation documentation. Written solicitation includes a solicitation that is publicly posted. The term superintendent shall be defined in the purposes of the rule. The meaning is superintendent or the designee. The superintendent may be authorized to purchase commodities contractual services where the total amount does not exceed the amount prescribed by the school board. It does not exceed the applicable appropriation in the district budget. The superintendent may also be authorized to purchase commodities and contractual services under the Department of the Management Services State Term Contractor. Assistant function under the superintendent directions may be authorized to perform these purchasing tasks. No person unless authorized to do so under the rules of the district school board may make any purpose entering into any contract involving the use of school funds. No expenditure for each of any unauthorized purchase or contract shall be approved by the district school board. 3. Before any purchasing policies. 3. Before any purchases of commodities or contractual services which the superintendent is authorized by the school district to make, or before recommending any purchase to the district school board, the superintendent shall, insofar as possible, propose the standards and specification. He or she shall see that the commodities or contractual services conform to these standards. The specification shall take such other steps as are necessary to see that the maximum value is being received for any of the money expended. In each school district in which the purchasing agent of any of the public agency authorized law to make the purchases for the benefit of other governmental agencies within the county, the district school board shall have the option to purchase under the current contracts as may be established for any other public agency set forth below the unit price stated here and there. The purchase in the economic advantage of the district school board, subject to the conformance of any of the items purchased over the standards specification prescribed by the superintendent for said district. As required by Section 1001-42, 10J, the Florida State Statute District School Board shall receive given in consideration of the price available to and under the rules of the Department of the Management Services Division of Purchasing. District School Boards may use the price established by the Division of Purchasing through its state purchasing agreement and price schedule. If the District School Board policy provides the purchasing under this program or the state of the purchasing agreements for the condition for the use shall be those imposed on the state agencies. 6. And purchasing policy. 6. In lieu of the requesting competitive solicitation for more than 3 or more sources, the district school board may make purchases below or specified prices of the contract award by the other city or county governmental agencies, other district school boards, community colleges, federal agencies, public governmental agencies of any of the state from state university system, cooperative bid agreements of the proper code, award of a contract under defined hereby in the permit purchases by the district school board at the same terms, condition, and prices below, and such prices awarded in such contract or such purchases are to be economic advantage of the district school board. 7. Except authorized by the law of the rule, competitive solicitation shall be requested from 3 or more of the sources of any authorized commodities or contractual services exceeding $50,000. Districts may not divide in procurement of the commodities of the contractual services to avoid the monetary threshold. The requirements of district school boards by the rules shall be set. This amount or lesser amount of this shall establish a purchasing policy relative to the purchase of a dollar value less than this formal monetary threshold. Purchasing policy 6A1012, purchasing policies number 8, the district school board shall have the authority to reject any proposal submitted in the response to any of the competitive solicitation requesting new proposals or purchases of the required commodities of the contractual services in any other manner authorized by this section. 9. In acceptance of the response to innovations to bid, the district school board may accept the proposal of the lowest responsible proposer. In the alternative, the district school board may also choose to award the contract to the lowest responsible bidder as a primary awardee of the contract. The next lowest responsible bidder as alternatively. Alternative awardees from the commodities of a contractual service would be purchased should the primary awardee become unable to provide all the commodities of the contractual services required by the school district board during the term of the contract. Nothing herein is meant to prevent the multiple awards of the lowest responsible bidders when such multiple awards are clearly stated in the bid solicitation documentation. In acceptance of the response to the request for the proposal, the district school boards may be awarded the contractors of one or more responsible proposers in accordance with the selection criteria published in the request for proposal. The district school board is not required to request the proposals for the purchases made by the contractors of the Department of Management Services as referenced in subsection 2 and 5 of this rule. The requirements of the requesting competitive solicitation for the commodities and contractual services for the 3 or more sources and hereby waived in authorized section 1010-04-4A Florida State Statutes 4. A. The purchase of district school board professional services, which include without limitation artistic services, academic program reviews, lectures by individuals, auditing services not subject to Section 218-391 Florida State Statutes, law of state services, including attorney, paralegal, experts, witnesses, court reporting, appraisals, mediator services, and health services involving examination, diagnosis, treatment, prevention, medical consultation, and administration. And the purchase by the district school board of educational services any type of copyrighted materials, including without limitation to educational tests, test books, printed instructional materials, computer software, film strips, videotapes, DVDs, discs, and tape recordings, digital records, similar audiovisual materials, and for library reference books, printed library cards where such materials are purchased directly from the producer and publisher, the owner of the copyright, an exclusive agent with it in the state of the governmental agencies or as recognized by the educational institution. And 12. Any additional exemptions authorized under certain conditions or requirements for the requesting competitive solicitation make the purchase for the commodities and contractual services as set forth in this section and are hereby waived as authorized in section 1010-04-4A. When the following conditions have been met in the district school board, competitive solicitation have been requested in the manner prescribed by this rule. The district school board has made a finding of the no valid acceptance of the firm proposal has been received within the prescribed time. When such a finding has been officially made, the district school board may enter the negotiation with the suppliers each of such commodities and contractual services shall have the authority to execute the contract to such as vendors under whatever the terms conditioned as the district school board determines it to be in the best interest. If less than 2 responsive proposals of the commodity contractual services are received, the district school board may negotiate on the best terms of conditions decided to reject all purposes. The district school board shall document these reasons, negotiate terms and conditions with the sole proposer is in the best interest of the school district in lieu of the resolicitation proposal. D. The commodities of the contractual services available only in the single source and may accept of the competitive solicitation requirements. When a district school board believes that the commodities of the contractual services are available only with a single source, the district school board shall electronically or otherwise publicly post a description of the commodities and contractual services sought for a period of at least 7 business days. The description must include the request of the prospective vendors provided information regarding their ability to supply the commodities and contractual services described, if any determination and written by the district school board after reviewing any of the information received from the prospective vendors that the commodities or the contractual services are available only for the single source of the district school board shall provide a notice of the intended decision to enter the signal source contractor in the manner specified in section 120.57.3 Florida State Statutes may negotiate on the best terms and conditions within the single source vendor. E. The district school board may dispense the requirements of the competitive solicitation for the emergency purchase of the commodities of the contract of services. Superintendent determines in the writing of the immediate damage to the public safety, health, and welfare and other substantial losses to the school district requires emergency action. After the superintendent makes a written determination, the district school board may proceed with the procurement of the commodities of the contractual services necessitated by immediate danger without requesting competitive solicitation. However, such an emergency purchase shall be made by the obtaining price information from at least 2 prospective vendors, which may be retained in the contract of hire unless contract file unless the superintendent determines in whether written at the time required of obtaining pricing information will increase the immediate danger to the public and health, safety, welfare, and substantial loss to the school district. F. A contract of the commodities contractual services may be awarded without competitive solicitation if the state of the federal law or a grant or a state or a federal agency contract prescribed with either whom the district school board must contract if the rate of the payment is established during the appropriation process. A contractor for the regulated utilities government franchise services may be awarded without competitive solicitation. Insofar as practicable, all purchase shall be based on the contract purchasing card system electronically. Procurement of the purchasing orders within the limits prescribed by the district school board, but the superintendent shall be authorized to approve the purchases under the rules of the district school board, provided that in so doing he or she shall certify the funds to cover the expenditures are authorized by the budget and have not been encumbered. Purchasing policies 6A1012 14. A district school board, when occurring whether the purchase, lease, and lease when the option, purchase, rental, and otherwise information technology is defined in Section 228, 282.0041.14 Florida State statutes, make any of the acquisition through the competitive solicitation process as described herein in the direct negotiation contract with the vendor or the supplier as best fits the needs of the school district as determined by the district school board. 15. Except for the otherwise required by the statute, district school board, when purchasing issuances, entering risk management programs, then contracting with a third-party administrator, makes them any such acquisition through the competitive solicitation process as described herein by direct negotiations and contracts. The rulemaking authority is 1001-021, 1006, 27, 1010. 04 Florida State Law 1001-42-4J 1006 27 1010 04 1 Florida State History News in December 17, 1965, amended in May 24th, 1967, September 1970. September 17, 1972, April 19, 1974, September 1974, republicated in December 5th, 1974, and in February 21st, 1977, and March 10th, 1985, formerly 6A1012, and amended in the June 27th, 1989, July 5th, 1990, June 10th, 1992, June 29th, 1993, April 25th, 1996, April 14th, 1997, and July 17th, 2000, and February 25th, 2009. 6A1013, pool purchases. Two more of the districts may be jointly pooled. The requirements of the resources designate one of the school board, the Department of Education, to act as an agent for all the requesting, bidding, and the purchasing of services or commodities. Each of the district participating in such a pool purchase shall pay its prorated cost to the district designating as an agent. Each district shall show only the net cost such as purchases and its annual report. The superintendent of the agent district shall, in each of the case, furnish each of the cooperation district a statement certifying that the purchase complied with the applicable laws and rules. If the Department of Education is designated as an agent pursuant, purchases shall be made in accordance with the requirements of the Division of the Purchasing of the Department of the Management Services. Such purchases shall be deemed to satisfy the legal requirements of each participating district. Rulemaking authority for pool purchases are rulemaking is 1001-01, 1006, 27, 1010, 04, Florida State Law, implemented 1001, 42, 4J, 1010, 04, Florida State History News, September 17, 1972, republicated in December 5th, 1974, amended in February 21st, 1977, formerly 6A113. 6A10141, categorical program funds. Categorical program funds identified in Section 1011-62 and any other earmarked funds allocated to a school district shall be expended only at the program for which the funds are provided. Any such funds, except for those categorical programs funded and provided through the contract or grant for the specific period of the time not expended by the school district as of the close of official year, shall be carried forward to the following official year of the same category or purpose. The rulemaking authority was 1001-021, Florida State Law, implemented 1001-001, 1011-62, Florida State History News as October 31st, 1974, republicated in December 5th, 1974, and amended in April 8th, 1975, formerly 6A1011, 6A10, 6A1.0, 6A1.141, which was before it was 6A10141. 6A1013 Promotion Public Relations Funding derived from the auxiliary enterprise and under designated gifts shall be disbursed in accordance with the rules of the school board for the school purchases that are deemed to be the benefit of the district for purposes of all those rules for the auxiliary enterprise will be denied by the profits, enterprise, and type activities of the distinct districts, excluding food service activities, which may be included or not limited to the vending machine, supply stores, and other internal account funded the profits not specifically designated for the students or school level purposes. From promotional and public relations funding, the rules of the school board may authorize the use of the portion of the school funds for the purpose of promotion, public relations, hospitality of the business guests, and provide that such purpose which directly benefits everybody in the best interest of the district. Promotion of the public relations activities may include but not limited to the activities involved in graduation visiting committees, orientation work, conferences, requirements for the employees, official meetings, receptions and guest speakers, accreditation, studies and other development activities awarded for other types of the recognition of the merit of his performance. These rules of the school board may authorize the use of the proportion of such funds and the hospitality of the business guests and disbursement for any of the official year for the hospitality of the business guests shall not exceed the following amounts. Funds used on purposes specified in subsection 6A10132 3 Florida administration shall be expended from the district fund which generated the revenue. The rulemaking authority was 101021 and 101008 Florida State History Law implemented in 101008 Florida State History News as in, July 26, 1984, for only 6A10143 amended in November 15, 1993. Funding refunding in the school district where any unfunded and delinquent indemnities existed is against the district general school fund when any of the other type of the unfunded legally incurred in such school indebtedness shall be duty of the superintendent to prepare the school board to approve the plan for retiring for indebtedness in accordance with the provision of section 1011-16 Florida State statutes to submit such a plan to the commissioner of the consideration. It shall be the duty of the commissioner to assist the cooperative of the superintendent and school board in any of the district in which a unfunded delinquent indebtedness existing may recommendation regarding the plan, including the determination of the funds necessary to operate, determining whether the remaining of the funds are available to retire the debt of the proposing any necessary modification of the plan. The district school board shall not attempt to retire any such debt until the commissioner has proposed recommendations. The refunding of the school district indebtedness is the rulemaking authority 101021, 1011-16 Florida State Law implemented 1011-16 Florida State History News, February 18th, 1974, repromulgated in December 5th, 1974, and in September 6th, 1978, formally 6A138, amended in December 20th, 2011. I guess that's the end of the slides. It should be. Okay, that was 6A1, all the financial slides and administration. Thank you.